wspólnego przedsięwzięcia. Poland in Silicon Valley Center for Science, Innovation and Entrepreneurship. Magnificencje lektorzy, szanowni państwo, dzisiejsze trzecie webinarium w naszym dialogu między naszym wspólnym Centrum w Dolinie Krzemowej i jego partnerami uniwersyteckimi w Polsce kontynuuje temat wiodący. Szukajmy wspólnych punktów zainteresowania. Szukajmy win-win opportunities. Tym razem jednak nie będziemy mówić o tym, jakie tematy wybrać do współpracy i wymiany, lecz jak je przygotować i zabezpieczyć, zanim rozpoczniemy pierwsze rozmowy. Pozdrawiam serdecznie i przekazuję mikrofon sobie, moderatorowi dzisiejszej rozmowy, Soody TRONSON. Soody, welcome.
Thank you, Piotr. Good morning, Piotr, and good evening to everybody else in Poland.
Some of you know Soody very well, those of you who participated in the top 500 innovators, others who might have worked with Soody TRONSON as a trusted advisor in aspects of intellectual property in preparation for journey to Silicon Valley. Soody, your topic is very important to, I think I might have lost you, so let's see whether I can restore my screen. Topic very important to preparing our, as I said, journey to Silicon Valley. One of the things that we have no doubt about is that Poland has a lot of intellectual property that is at the top of the world. However, we also know that we are not the only one in the world that is trying to find unicorns, to find opportunities to become leader in the world. And not everybody plays the game the same way. Therefore, we have to protect ourselves. We cannot naively come and wave the flag and say, here we are, admire what we do, work with us. There will be those who will look at us and say, I could take this and work with it and accomplish something faster without them, and maybe I could claim that it's mine. To avoid that, we have the intellectual property systems worldwide, however different in various places in the world. Soody, what are the first thoughts that come to your mind when you think Poland coming to Silicon Valley with its brightest and best?
Well, my experience, which has started actually before even the top 500 program with some of my other Polish American clients and friends, and actually was more emphasized as I became more familiar with the Polish innovation culture, is that Poland is absolutely beautiful, not just from a country perspective, but also from the innovations and the innovators that it fosters and the developments. One of the things that is not necessarily unique to Poland, but my experience has been with Poland more, is the lack of familiarity with the US IP system, whether it's patents, copyrights, and so on. And what I think would be most important is to actually enhance some of the, on the patent side, for example, some of the disclosures that we get in order to provide enough appreciation for the protection of the innovations that come out of Poland. So I think there's a lot of opportunity there. There's a lot of solid technology, not just, Me Too type products or innovations that I've seen out of Poland. So I think there's a great amount of opportunity to protect the IP rights of the Polish entities that want to enter into the US or just want to have some sort of a market presence in the US.
So step number one, maybe, I know that for our colleagues in Poland, where the discussion on IP protection is as old as independent Poland since at least 1989 or maybe before. And we had many symposia. You participated in them. We had the program Top 500. We had various conferences in Poland. They are still happening. Poland has a robust system of discussions about how to patent, what to patent. It has centers at the universities that are doing all this. So why do they need to hear from us?
You mean from the US side of things?
From us in the Silicon Valley, yes.
Right. So let me first say that, of course, intellectual property is more than just patents. It's trademarks, copyrights, privacy rights, data rights. It's a huge ecosystem of various types. We normally focus more on what I call the magnificent five, which are the patents, copyrights, design rights, trademarks, and trade secrets. So in that sense, they are very critical in the sense that in Silicon Valley, especially, a lot of the investments and also exit opportunities rely heavily on the IP, especially patent portfolio of technology-driven companies. And so one person or one company may have great ideas and great inventions and innovations, but to get the value that it rightfully deserves, they have to have some protection of the intellectual property for various reasons. One is an asset, right? So it provides more valuation for the company, therefore more funding is available. The chances of successful or higher exit values are also influenced by the IP. Now, it doesn't mean that in every single situation, a patent filing is warranted. But if you're a technology-driven company, the chances are you need to have it. But also, when it comes to getting into Silicon Valley and understanding some of the issues, whether you're a software company or otherwise, there's also some very critical distinctions, both from the perspective of protecting your own IP and also protecting your own assets from, let's say, people who want to sue you down the line. So, for example, copyright regulations and laws are very different in the US than they are in Poland and European Commission, as Union and other European countries. So it's really important to understand those distinctions because they will make a big impact on the success when people enter or companies enter the Silicon Valley or the US market.
One of the things that fascinates me about your area of expertise is that when we talk patent IP, we always think about the initial inventor and the steps by the initial inventor. But then there is a slide that you showed to me. Maybe I will share it for a moment, if you allow me.
Of course.
Let me share it. Let me share it. I have it on the screen. And I will share it here. Okay. Can you see it?
Yes, I can.
Okay. That wonderful slide that shows that the road to success requires many entities being involved. There's the initial inventor. Let's call him the academia, the university, the researcher, the brilliant person who woke up and shouted Eureka. But then it builds up into an entire cosmos of entities involved. And all of those entities, step by step, have to understand to different level what you are doing. So by the time you come to Silicon Valley, there are at least 2-3 dozen entities that have that are remotely linked to the initial inventor, to the owner of the idea. And they also are linking now to others. Let's say an initial investor in Poland puts money into the idea of that inventor, to the startup, the Polish startup. But the initial investor in Poland, let's call it maybe even pre-round A, maybe family is too close, but the initial investor, he doesn't, or he or she doesn't have enough money to continue investing. So looks for links with further investment groups, maybe looks for a link abroad, and carries some form of the original deck. What's happening in this cosmos? How do you continue protecting yourself?
So let's say, as you suggested, let's take something, an invention coming out of a university. Now, I've had the pleasure of working with some of the universities in Poland as well, perhaps not directly, but through their council, for a local council. So what happens is typically applications or inventions get filed through local council in Poland, obviously. Then there could be potentially what happens at the ownership level, of course, is a separate story, because the university inventions can be used to spin off a company, or most often they're used as a licensing tool, right? So they're usually licensed to some other entity. So you've got the university, you've got the Polish council, who may or may not actually prosecute or do the back and forth with the European patent office. Sometimes they do, sometimes they actually send it to another council who is more familiar with the European practice. And then we also, at the US side, we receive the applications to file in the US system. So there's a lot of players, and to the extent that it's a university, then there's a question of who do they want to license that invention to. So then it becomes a question of where that other potential assignee, the entity that gets the license, resides. Is it in Europe? Is it in the US? Where are they located? So there's a lot of players, a lot of different monetization models, whether it's licensing or sales, like a spin-off, or as well as the rules and regulations that govern those relationships. Now, we have to remember, at the end of the day, when I'm gone, somebody else is gone, and 5, 10 years down the line, and something happens, it's the words that matter, meaning the words in the contract for the licensing, or the words in the patent application. A lot of times patents, even when they're issued, they're not challenged until years later. You really don't know what the value and or the issues, maybe the vulnerabilities of that application that turned into a patent, what they were, because you haven't tested it yet. So there's a lot of players there. It takes a lot of planning, a lot of foresight. And I think the biggest advice that I have is to ensure that IP, if it's to be decided, the strategy for the IP is treated as any other part of a business strategy. And although things do evolve, we have to remain flexible and be able to react to new circumstances or positions. It's really important to plan whatever it is. And plan doesn't mean you have to file something. Plan means knowing whether you're going to file or not file something. So I think planning ahead of time is one of the wisest approaches to ensuring that you're well protected.
In our discussion, you pulled a slide that horrified me,
Which one?
which you call the IPRS to consider. Do you want to pop that one? I don't want to scare anybody.
I see. Okay. All right. So
But
let me share. I will share that one slide, if I may.
I want everybody to be aware how complex it can become. It can
Okay.
become about as complex as the molecule that you invented and you are trying to bring to market.
Right. Right. So I'm hoping that you see the
Yes,
slide.
we do.
So this is kind of like what I was mentioning earlier, that IPRs, or intellectual property rights, is what is needed in order to protect. So it's unfortunate if you're not at a day and age where you will leave your wallet on the countertop at the store willingly and walk away with it and think that, oh, it's not gonna be taken or stolen. So IPs are created, whether by Polish innovators or any other innovator. But again, we are at a day and age that if you don't protect the right, if you don't turn that into a protectable right, you're going to lose it. That's the reality. So there are a lot of different types of intellectual property rights. For example, copyrights, trademarks, design rights. You got utility models, you got trade secrets, so you have plant variety. And then you have a whole bunch of other kind of IP, which is like right of publicity, which is quite relevant in Poland. For example, data, as we know, is taken over the world. That is also an IP that could have its own rights and moral rights, which are quite strong actually in Poland. So, and depending on the business, they can be used for protection of different type of assets, whether it's confidential information, it goes into your branding, or you're creating some sort of a creative content. And for the most part of what I see from Poland, of course, is the technology aspect of things. So it's really critical to understand that IP is a very large and complex world, and there are a lot of distinctions in the different jurisdictions. Piotr, I can't hear you, unfortunately.
I am back. I got interruption in the line. I am back.
Okay.
Uh, I am looking at this diagram, and I think I understand all the words that are on it, but I'm not so sure. So I'm as the technology guy here. Actually, Soody is also an engineer, but and then she went astray and became a lawyer. Nobody's perfect. So, I'm looking at this, and the only color I recognize is the pink one, which is technology and innovation, and the rest of it is sort of fuzzy. Copyrights. If I have a patent of my technological development, where is the copyrights coming into it?
So for example, let's say you write a software, so you have a software related invention, which could very well be patentable, assuming there's enough technical content. You may also protect parts of it as a copyright. Or you may, again, if you're talking about technology driven companies, but remember, you can also copyrights goes to movies, to illustrations, to works of art. Those are all part of copyrights. But from a technology perspective, so are software codes and everything else. Now, talking about copyright, for example, one of the key distinctions between Poland and the US is that, yes, both countries recognize copyrights, and in the US, copyrights don't have to be registered in order to be recognized. However, if you want to take somebody to court or get what is called statutory damages, that is those penalties that are set by law, you have to file and register your copyright. There is no such, as far as I know, there is no such parallel requirements in Poland, for example. So if you do happen to have something that copyright protection is going to be a valuable right for your company and you're coming to the US, you may want to consider, I strongly recommend considering registering it, because without registration, you don't have some of the rights for protecting or getting some of the rights, like taking somebody to the court or getting um, certain kind of penalties, or as we call them, damages.
Before we go any further, I would like to suggest to our participants that if you have any questions, there is a box there, Q&A. If you write your question there, then towards the end of our meeting, I will be picking out of that box some additional question to Soody. So don't feel shy. Whatever comes to your mind as you listen to us, write your question in. Okay. Now, so that's copyrights. Is trademark a little bit like copyright, right? What's the difference?
So so trademarks, the purpose, regardless of where a company is located, the purpose of trademark is to help consumers understand the origins of something, who's behind, whatever the brand it is, the brand of cereal, the brand of car. Those are all trademarks, right? So that Coca-Cola is a trademark. So that is the purpose behind trademarks. Now, like for example, in US, I mean, in Poland, similar to the rest of Europe, you can go ahead and register for a trademark without even using it. Now you've got, I believe, about 5 years or so that if somebody does not use it, it can be canceled. But that's very different than in the US, in the sense that in US, there is again no requirement for registering a trademark, but again, it has a lot of advantages. But the way that trademark law has evolved in the US is based on common law, which is very different than most of Europe. And it is based on who used it first. Now, you can use it first and file for it as well, but it's based on usage, not based on who filed it first. So sometimes companies coming from countries where trademark protection is only afforded upon registration don't do a proper search to make sure they are not infringing somebody else's trademark when they enter the US, because they only search in the US trademark office if some mark has been registered, and they don't think that there is this thing called common law trademark rights, which doesn't require registration. So then they can fall into a problem of infringing somebody else's trademark without ever intending it, but it's just because of lack of familiarity between the different systems of law for protection of trademarks.
And we know it can be very painful. Even at the U.S. Polish Trade Council, we have learned it the hard way. We, in one of our web displays, we had a quote to something, and we had a picture from something. And we posted that picture, and a few years later, your colleagues, lawyers, knocked on our door and said, you owe such and such pile of money because you have used their property without permission. And they were not unreasonable, but they were costly. And
Yes.
we had to pay. And it
Oh,
was this classic of what you just said, We intended no harm. As a matter of fact, we thought we promote this particular picture, and yet it was costly to us. And as an organization, we really were very sore afterwards. Yes.
no, absolutely. And that unfortunately happens more than you can imagine, especially when it comes to websites. There's so many scams out there with respect to websites that put other people's property in form of pictures and images and say, oh, free download. And most often I've had clients like this. I don't do litigation, but I do a lot of pre-litigation settlements. And I recently settled a case on a copyright infringement for just a small business website, because the website developer went ahead and grabbed a photo from some site that he said, oh, free, you can download whatever, no payment necessary, but they didn't bother reading the bottom under licensing that it says, you get what you get. We'll give you whatever we have as far as rights are concerned, nothing more. And they had no rights. So, there you go. A simple, so nowadays, every time I have a client that I need to advise on working, let's say, with a website developer or social media content developers, is make sure you have the license to every image that you don't create, that is in your name. You buy it, you keep it, not your website developer, because you never know where they're going to disappear to tomorrow. So yeah, that's, I would say, familiarity. And of course, I understand innovators have more important things to do to try and navigate all of these things. I think my biggest, most important advice is be aware, know enough about the issues so that you can see when you're at a juncture that you need support. I think that's the biggest role that, as an educator, if you're tasked with, is just providing enough of what the world in our, each of our worlds are, so that innovators can understand that, hey, I'm getting to this point. I think I'm using images. Do I have all the right copyright protection, or have I am I using somebody else's copyrighted material without permission? Just enough for them to raise their hand and say, okay, it's time to talk to an advisor. I think that's the biggest thing that we can expect and should expect from innovators, because they got better things to do than worrying about the legal aspects. They need to innovate.
Also, the Poland in Silicon Valley Center for Science, Innovation, and Entrepreneurship is in close collaboration with 10 universities from Poland.
Mhm.
Those universities now are putting together packages of things that they would like to shoot to
Mhm.
Silicon Valley. The message, we are brilliant. Okay, a general web page of Polish university is just as good as most universities in the world. But then we get into more detail. The university A or B is putting a number of projects into a general pool.
Mhm.
Those are the projects that they selected by their internal wisdom, thinking that those are the projects, or assuming that those are the projects that will impress the world and this will develop relation. So we have established, for starters, an ambitious program that each university will put six such projects. So suddenly we have from Poland 60 projects that are saying to the world, we are the top of the world, watch us. Okay?
Mhm.
So we are going to take it and present it further. What are the things that we should be watching for when those projects land in Poland, in Silicon Valley Center?
Okay. So actually, the European law, which is similar to the Polish law itself in respect to disclosure, is that this absolute novelty. That means if you speak enough content that somebody can understand what your claimed invention is, that will prevent you from being able to file for a patent application, which is the case in Europe and Poland, obviously. In the US, there is a limited duration of 1 year where if that disclosure is made by the inventor, they have that grace period before having to file. But and we typically call, there's also the provisional application, but that's a little bit different. So the biggest issue is that, forget that the US has a 1 year grace period, because that's very limited. You're going to lose, if you're a Polish university, obviously you want to file in Poland and Europe as well as US. You have to be sure that you have not uttered a word about details of the invention to anyone, including posting it on a website and otherwise, without having first filed for a application. And then as it relates to disclosing it to other people or entities without having filed during the early stages of decision making, you need to make sure you have enforceable, and I can't emphasize the word enforceable, non-disclosure and non-use agreements in place. NDAs unfortunately, and for this two sides of the same coin, with the, the internet and everything else, accessing information is extremely easy, but it's also accessing misinformation or incorrect information is also very easy. And NDAs are one of the more relatively simple agreements. However, they're some of the most litigated agreements because everybody just goes from the internet and downloads a file, God knows from where, and they use it. So that's what I mean by the word enforceable and properly drafted. So my recommendation would be, one, while you're still assessing whether you want to undertake the issue of filing for, let's say, a patent application, that you put NDAs in place with every company, every person. Don't ever lose sight of common sense, because contracts are good. You go, sue somebody, but more importantly, what can you do so you never even get there is pick your partners right, do due diligence. One of the most important things is doing due diligence, because every website says the same thing. I'm so great and I'm so cool, and I know so much and I'm such an ethical person. So it's hard to tell the integrity of the partners that we pick. So word of mouth and recommendations are extremely, extremely important. I've had the pleasure of working with several um, um, countries' investment arms that in the US, and I usually tell them that you need a champion, not just a consultant, not just a advisor. You need a champion that is actually going to watch out for where things are, because as great, I don't think we've discussed this, Piotr, but as great as a lot of opportunities are in Silicon Valley, you also have to, and people have to also understand that it's kind of like Hollywood, in the sense that it's a great place of creation, and like Hollywood's a great place of creation and the home of movies and everything else, but it's also an industry, right? There's a lot of people who are not ethical people. Same thing in Silicon Valley. You need to have a champion. And I think that's why the Polish Center is such a valuable resource to advise the universities as they're trying to expand into the US market.
This is why we invited Soody TRONSON, and she accepted to be part of our team. And we felt that it's very important that we have on our team direct access to a person who has the experience, knowledge from here, but also worked with the Polish side. And so don't be shy. Come and ask. We just got a question. I will, because we are on this point, I will read the question. If I have a patent and present it with some ideas to investors in the US, should I also make copyright to my presentation?
Not necessarily. If your presentation is not creative in nature, copyright is usually reserved for creative endeavors. Yeah, of course, software is also included, but you're not going to put software in your presentation anyway, the details of the code. So to the extent that you're providing, like for example, let's say I create an image for a presentation, I can go ahead and copyright it, because although the facts are not copyrightable, the way I present it may be. So just a mere presentation for a pitch deck in and of itself is not necessary. But if you have images in your presentations that are unique to you and they're creative, your pictures of your products and otherwise, you can always put a copyright notice. And you don't have to register it, at least you can put a notice in place. So some of these are best answers on a case by case, depending what that content is that you're trying to share.
Okay, so before we get to the big elephant in everybody's room right now called AI, I would like to get a little bit into the broader picture of positioning your country in the intellectual property world, and little bit about where Poland is in terms of issuing patents, propagating the patents to other countries, first EU and then US. Could you comment a little bit on it, some comparisons,
Sure.
some encouragement and some criticism? Don't be only positive.
Of course. And the other thing I would like before we end today's conversation is also talk a little bit as a reminder about some statistics on the value of filings to young companies, both from investment as well as, if I may do that first, Piotr, with your permission. This is one that I wanted to, so the on the left is some data that I have from US. On the right is actually from the EU of intellectual property office. In that, again, these are not absolutes, especially what's on the left. These are just summary advice. Is that typically, and this information came from the Intellectual Property Asset Management magazine, which is a very influential and well-researched, research company for information, is that, as you can see, typically, again, we're talking typical, is that if you're pre-money, let's say you need at least one patent. If you're post initial funding after your seed round, you need 2 to 4. So sometimes people say, well, how many patents do I need to have? Well, it depends, first of all, on your field of technology. Not you cannot have, it's not the same for every, like medical devices may be different than software from manufacturing and so on. And I have that data as well, but I don't want to make this discussion about data per se. And then as far as the data on the right side is concerned, the left was information about how many companies or events were used to generate the 2 other panels. So the users, this is not unique to Poland, by the way, this is from the European office, is that if you're just focusing on patents, which is a dark green, you can see that seed stage, there's like about 10% of them are using patents. And then by the time they get early stage, it increases. So the idea is to show you that patents are relevant and are being done right now. And then the other thing that I wanted to mention is that the investments, that having patents increases the odds for exit for startups with the prior patent or trademark applications. And then if you have, let's say, just a national application, meaning like just a Polish application versus more international, in this case, it's just on the European, you can see that there is an increase in odds of funding when you go beyond your initial country. So in terms of filings, then this is the more recent data, but the office didn't have more than the 2022 that has been actually, so they published it like in 2023 for 2022 and before, and then later this year we'll get the 23 results. So the main, there's like, these are the top 5 Polish universities with academic patents. And then in the EPO, European Patent Office, the number of Polish applications is on the rise, which is great to see. So we are on the right trend as far as that is concerned. The other piece of information that might be useful, let me see if this is the one. This is showing the number of startups that are based in the US, or about 10% of the total, have filed patent applications on academic inventions stemming from European universities, right? So this shows the collaboration. What we're talking about here is there is collaboration between US entities and European universities. So universities in Europe, and Poland is definitely on the top as far as I have seen in terms of innovations coming out of it, are extremely attractive partners for US companies as well. So the key thing is you have to have a right in order to monetize it. Just having the technology, if it's unprotected, you cannot do anything with it. The people are just going to take it. You might rely, let's say, on trade secrets or know-how, but that is most often also licensable, but it's more, it's not the same as patents. So to the extent that you can patent something, you need to do that. And then
Soody, could you go back to that slide, because
this one?
I don't want us to get out of here having
Sure.
excessive level of comfort.
Mhm.
The red line I
That's
want
Poland.
everybody to focus on the fact that this is Poland. I want
Yes.
us to focus on the fact that the countries that have pushed their patents into US from EU are France, of course, Germany, of course, and then Italy, okay, Netherlands, of course. But then we come to countries that entered this world scene together with us, which are well ahead percent-wise from Poland. So there is something systemic because we know that Polish science produces a lot of good science and produces a lot of good research, as proven by the fact that when Poles appear on the international scenes, they find very cozy positions at leading universities, at top corporations, R&D centers. You want to go to NVIDIA, you will find Poles there. You want to go to Google, you will find Poles there. You want to go to Meta, you will find Poles there. You want to go to Genentech, you will find Poles there. So what's going on? Why are we asleep? That has to be addressed very systemically within universities. And we are not talking today to corporations. I have the same note to corporate R&Ds, but particularly to universities. Of course, there is always a question of price, of cost. And maybe when you are done with your next slide that you started and I interrupted you, maybe we should get into the question how much of your money that is available to you in seed financing, in subsequent stages, you should spend on patents. If I may, Soody, some of you know in more recent part of my career, I started company which is now called XGS Energy, used to be called Geothermic Solution. Never mind what the company does. We had very little money. We filed for some patents. The patents were not something that I would today write home about, but they were patents. I could start talking to investors. And so I said, yeah, I have patents. But today, when the company is already implementing large-scale projects, the company is reworking very vigorously, reworking the entire patent portfolio. A lot of new patents are being filed, and the old patents are being reviewed again for how solid were they, how good a protection they provide. And we are working on some of those old patents, creating new patents that don't interfere with the old patent, but make our position in that territory stronger. That's money. That's big money. Experts like Soody don't come for 1 zloty. So you have to have the resources. So it's not only that you have more patents, but your patents are more elaborate and probably more costly. However, my long monologue here is towards changing the picture that we are looking at right now. Sorry, Soody, go
No,
ahead.
no, 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 no. But no, that's so none of us wants to spend money, especially if we cannot wear it, drive it, the fun stuff. Legal expenditure is never the fun stuff, even for big companies with a lot of money. Is most legal departments, unfortunately, are viewed as an overhead as opposed to a revenue center. But patents IP is actually an asset, so it should be treated as an asset, not as an overhead issue. So this is a cost of buying and securing and procuring your assets. So it is, again, I'm not saying you have to file for a patent or file this or that. All I'm suggesting is making sure that that is part of your conscious decision-making process so that you can make those informed decisions at every stage of your company's growth. But going back to this also this is also from WIPO. You hadn't seen this one. I just got it late last night that I was looking, is the top technical fields, let's say coming out of Poland, our from a patent perspective and WIPO perspective is from like medical technology, civil engineering, things that I, as a former, well, I said I'm a scientist, an engineer, you never give that up. I truly love is true innovation, which Poland is notoriously, in a good way, famous for. So that would be, there's a lot of room for that in here. And then this one last one more from just a perspective of historical perspective. There's a lot of this great information. I don't want to belabor this because I'm not a Polish expert. You are. And all of this information is available. And of course, I'll be happy to share the extracts that I have done here. But again, remembering that when you're doing your IP, let's say you're doing your patent side of things, is valuable for so many different things. I remember when I was an engineer at Hewlett Packard many years ago, well, way before we had internet, by the way, the accessible internet for everybody to use. We used to get these printouts. There were probably five, I swear, there were probably 10, maybe 200, 500 pages every week. I would get them and I was doing my engineering product design work, but I also had an interest in IP and used to use that for competitive intelligence. Now imagine doing that hard copy style, copy paste. It wasn't even a copy paste, it was all printouts. Nowadays it's easier, but being aware of IP is useful in so many ways. It's not just protecting your own stuff. You can use it to vet your potential supply chain partners, right? Your other licensing partners. There's a lot of value in having a comprehensive IP strategy. So what are some of the other topics you think our colleagues might be interested about hearing, Piotr?
Well, if we don't move immediately into the question of AI and what's happening in the patenting in the AI world, we would be amiss. So if you could dive shortly into that, and we have a few questions piling here that I would like to give people the chance to hear your opinion on those questions.
Right. So AI has software components, right? Software applications as well as hardware. So hardware, we know so there's a sometimes misconception or a belief that software or AI is not patentable. It is. It just has to be technical content, not marketing content. That's one of there was a recent, just this month or past, there was a decision from the European Patent Office Board of Appeal on that invalidated or rejected certain claims having to do with AI. And the main reason, the takeaway, was that there was not enough details, there was not enough content. So let me show this one first, and then we'll go back to the other slide. So this was basically the EPO's decision, and I have the reference here as well, is that AI, as you know, is at least right now is taking over the world, and there's a lot of great, just like there are a lot of other technical software that is coming out of great innovators, including those from Poland. You have the idea, you have the invention, you cannot cut corners when it comes to disclosing it. You have to have very clear definitions. Don't take it for granted that, let's say, regression analysis is already known and is part of something that, let's say, an AI system does. You have to describe the type of model that you're using, the architecture, the specific algorithms, and so on. You have to explicitly state them, not just for US, but also for European protection. You have to map your parameters. You have to have your training procedures depending on what it is you're trying to get protection for. And don't be shy and short on working examples if you have them. So the takeaway message is that yes, AI and software are patentable, but they require a technical advancement and technical features. And the US and Europe call it different things. but they both focus on technical attributes. Sometimes, and this is not unique to Poland, but sometimes even in US or whatever, when I get a disclosure, especially if it's software, has a software element to it, sometimes people present it more as a marketing literature as opposed to technical. And I think part of my initial 1 hour conversation with my people that I advise is this: I'm not judging the company or its ideas or innovation, how much of a market need there is or what kind of attraction they're going to have. That's for the marketing people. More power to them. I don't understand marketing. I don't do marketing. What I care about is technical. Bore me to death if you have to. Give me details. Now, the details that are not relevant, I will not put them, for example, in an application, but details are extremely important. And yes, again, going back to the idea that yes, you can patent AI, there's several types of claims, as you like to call them, or inventions that we direct our claims to. They could be, of course, the hardware part of AI. That's more easily understood because it could be CPUs, interconnects, chips, and so on. But you have there's at least 4 other general categories that claims can be directed to. So how you generate training data for use in a training model. How do you train the model using that training data, using the trained model to analyze data, and the trained model architecture. Those are all the different types of buckets of inventions, broadly speaking, that an AI-related invention can fall into. So my advice is, yes, it could be patentable. And if it is, you please make sure you provide details from from a technical perspective and not marketing perspective.
Okay, we have 8 minutes left, and we have a whole series of questions. We will not be able to address all of them, but let me pick and choose few and quick answers, so maybe we'll cover as many as possible.
Sure.
So one question is, when created a company, whose name should be on the patent if the CEO isn't an engineer?
If the CEO is what?
Not an engineer. He's not an engineer. He's
You
not
don't
the
have to be.
inventor.
Okay, well, first of all, US has very strict laws as relates to inventorship. Inventors are inventors. There's no buts and ifs about it. And inventorship is different than scientific writing. A lot of times bosses or managers or whoever like to put their name on a scientific journal. Inventorship is extremely different. If you ever need a bad guy, if you feel shy telling your CEO that he or she cannot be listed as a patent, blame your attorney. I've played that bad attorney role many times. If inventorship is incorrect on a US patent application, it can lead to a lot of enforceability and validity issues and problems. So you cannot shortchange or not name somebody who is an inventor, and you also cannot name somebody who is not an inventor. Now, the inventor is inventor. Ownership is different. That's your assignee or your applicant, right? So there are different things. You can be an inventor but not own the patent. Kind of like you work in a company, you invent something, but you don't own it because it belongs to your company.
So next question could be leading to a full lecture, but let's see what we can do with it quickly. When you say patents, do you mean a patent application or a granted patent, accepted one? Which one do you mean? When you say you stand in front of a public, you say we have 3 patents.
Oh, patents are not patents unless they are issued. And they are maintained. What I mean by maintained, similar to Europe, where there's annuities that you pay each year. In the US, once something has been, you file an application, it goes through a formal proceedings in the patent office, whether it's Europe or US. And at the end, if everything, and then there's a lot of back and forth that happens. Sometimes it takes a few years. Then you hopefully get issued, the application issues or gets granted as a patent, right? So then it becomes a patent. And then in the US, you have to pay what is called maintenance fees, which happen like 3.5, 7.5, and 10.5 years after it has been issued. You have to pay certain sum of money. It's similar to annuities in Europe, except it's every so often as opposed to every year. So you either have an application or a granted, which is the same as issued patent. And of course, it has to be maintained during its life by paying those extra fees.
What is the most common mistake in IPR management done by companies from Central Europe coming in the US market?
On the patent side, I think the biggest problem that I see is not the idea or the invention itself, is how it might be presented. And please don't get me wrong, I'm not saying that the stuff coming in from Europe, whichever parts it might be, is not good. It's just that if I had to pick some of the issues that I've seen on and off, is that there are, especially if it's software, they're short on technical details. And also sometimes the inventions are described a little bit too narrowly. There could be a lot. Remember, you can have different, what we call like claims have, it's like a funnel, different scopes of protection. This is my invention, this is my invention, this is my invention. And that's how claim funnels work. But for everything that you want to have protection for, you need to have disclosure. And if put as much of the details as you can in your original application, and then let the attorney in their back and forth with the relevant patent office figure out what is the scope that you are entitled to have as a patent at the end of the day. So make your disclosures more technical and make them broader. Then I have enough, as an example, it have enough material to work with, because US patent practice is extremely different than European patent practice. The laws are different, and remember that the US is based on common law. So even though we have statutes protecting, aspects of patents and protecting inventions, the interpretation is by the courts. And each year we have a different case law. And we can't even keep up with all of that, let alone our European colleagues. So it's really important to know ahead of time some of the considerations for US practice. And work if you are continuously churning out inventions, especially if you're a university, get to know your US practitioners. And some of you may be in the chemistry field, might use the word chemistry more generically. You need to also have a good chemistry with your attorneys, so you feel comfortable discussing issues with them.
Okay, we are coming to the end of time, so I will try to cram two questions. One is basically yes or no, I hope. Do you need to set up a US entity to be more likely to be successful in a patent application being accepted?
No.
Okay, thank you.
That's relatively, not from a patent perspective.
Okay, next question. Where can you find examples of patent forms so we know how to write a technical document?
So there are no patent forms for writing technical document. What we usually use, and I have some on my own website, is called a disclosure form. It's called an invention disclosure form. It's more like an interrogation where I'm putting you on the hot seat and asking you, well, what about this? Well, did you think about this? Did you think about that? Patent drafting, the role of the patent attorney a lot of times is to bombard you with questions. Happy to share my own invention disclosure form. It's nothing magical about it. It's all about Q&A, trying to elicit information from the inventors. Sometimes the best tools or teaching means are looking at other good patents that have been written, more importantly, litigated. And we have a huge bank, hence hindsight is 2020. There's a lot of cases that go to court, and then we learn from them, not because the attorney did anything wrong, but just, things evolve. and we are always learning. So reading some of those disclosures, some of those opinions are extremely important. And that's something we do as opposed to having to burden our inventors having to do.
So the warning from the inventor side to all of you, before you go to your patent lawyer, take something calming and be very, be very relaxed. I can tell you it's a tediously annoying process when somebody starts questioning what you are saying and starts
Exactly.
questioning it again and again. It's like being in the courtroom and being a deposition, if you know what deposition
And
is.
that's the first thing I always say is like, I apologize always upfront to all my inventors. It's like, I'm not judging their invention. I'm trying to grill them to the best I can so that they're in their strongest position, kind of like a trainer of a boxing champion.
It doesn't feel like it, Soody. It feel Thank you very much, everybody. Thank you, Soody TRONSON. That's great. And as I said, you have access to Soody through Poland and Silicon Valley Center for Innovation, Science, Innovation, and Entrepreneurship. And look forward to seeing you at our next webinar. All the best. Thank you.
Thank you so much.